Hello everybody, I'm John Victor Ramses. I'm going to be reading a lengthy document that I was invited to produce for the Australian Productivity Commission Access to Justice Inquiry in December of 2013, while I was still in Acacia Prison, Western Australia. Now this document, which is about 45 pages long, covers everything from the handling of my case, the treatment I received by the Australian legal system, and the relevant laws. Again, it's a lengthy document, so I'm going to be breaking it up into multiple videos. I feel that reading this document now, exposing what I went through and what I wrote about nearly a decade ago, is relevant now, as we've all seen the corruption for ourselves in the legal system this past 4 years. In this document, I'm speaking primarily of the Australian legal system and the judicial, and the blatant corruption used to put me in prison. However, this also applies to the legal and judicial system of the United States of America, and probably every other legal system on the planet. Now, the Australian Productivity Commission did receive this document and sent me a letter to that effect. However, they decided not to include my submission in the inquiry, probably because it was just too truthful and too damning, and opened up a nasty can of worms. So without further ado, I'll begin reading this. Submission to the Australian Productivity Commission, P.O. Box 1428, Canberra, ACT 2601. Access to Justice Inquiry, compiled 7 December 2013. Submission by John Victor Ramses, United States citizen, age 53, prisoner at Acacia Prison. Prisoner ID D 2174691. Mailing address, Acacia Prison, Locked Bag 1, Warraloo, Western Australia. The document begins with these quotes. The prospect of an innocent person being convicted of a serious crime represents a catastrophic failure of our legal system. That was by Lord Igor Judge, Chief Lord Justice of England and Wales, speaking at the Australian Institute of Judicial Administrative Conference in Sydney, Australia, September 7 and 9, 2011. That everybody who comes before a court is entitled to a fair trial is axiomatic. The right to every citizen to unimpeded access to a court is a basic right, citing Martin Hinton, QC, in Unused Materials and Prosecution's Duty to Disclose, Volume 25, Crim. LJ 121 to 139. Most Australians would probably be shocked to learn just how often people face prosecution and conviction without any competent legal representation. There is mounting evidence that more and more people are forced to represent themselves in criminal cases, citing Dr. Carmen Lawrence, former Premier of West Australia, in her book Fear in Politics, 2006, page 70 and 72. The hard reality is the cost of legal representation is beyond the reach of many, probably most, ordinary Australians. Citing Chief Justice Wayne Martin, the West Australian newspaper, 25 October 2012. The resources that are mobilized by the state are immense by comparison to those generally available to the accused. Citing Unused Materials and Prosecution's Duty to Disclose, Volume 25, Crim. LJ 121 to 139. In determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees in full equality: to defend himself in person or through legal assistance of his own choosing, to be informed that, if he does not have legal assistance of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any case if he does not have sufficient means to pay for it. Citing the International Covenant on Civil and Political Rights, Article 14.3. The ICCPR was ratified by Australia on 13 August 1980 and entered into force for Australia on 13 November 1980. The purpose of this submission to the Access of Justice Inquiry is to contribute my personal experience with the matter on review, particularly fairness to the accused, which, in my circumstance, includes denial of legal representation for a criminal matter, being forced as a result to face criminal hearings and a 5-day trial alone in a foreign country with no knowledge of the complex domestic laws or trial matters. The stress, helplessness, anger, fatigue, and fear of being left abandoned in a foreign country to face it alone. Additional issues addressed include the dire lack of reasonable access to facilities and resources to properly prepare legal letters and documents, including access to a computer, printer, law library, and the basic assistance guidance for prisoners on how to properly prepare legal documents. This submission is presented through the viewpoint of a foreign national, a United States citizen faced with litigation in Western Australia, and is written in the vernacular of an average person. The combined experience has been, and so far remains, a shameful atrocity of justice, unbecoming of a modern civilized nation whose political members, while in the global media spotlight, tout Australia's commitment to fairness, human rights, and respect for the UN Charter and international law, yet in practice demonstrate the opposite is true. Included with this submission are excerpts from my own trial, clearly depicting the impossible position an accused is actually confronted with when forced to face trial unrepresented, particularly as a foreign national in a foreign court. These transcripts exploit the apparent indifference to the situation by the trial judge as well. The transcript clearly shows my pleas to the judge before the jury, telling the judge that I don't know what to do. I seem to be at a loss. I don't know where to go. I'm not a lawyer. I can't defend myself, Your Honor. I have the evidence, but don't know how to show it. I'm just learning through this, but I'm catching on. But which comments and pleas were ignored by the judge. As a reasonable-minded reader shall see through the course of this submission, the emotional and physical burden of attempting to defend one's own self in criminal hearings and through trial, with no knowledge of legal matters, and where the very life of the accused is at stake, can only be described without exaggeration as cruel, barbaric, or, at least exceedingly, unfair, biased, and prejudiced. The impact on my life, family, and health is irreparable. Furthermore, as members of the review committee may be aware, such circumstances as being denied legal representation where the interest of justice so require is in obstinate conflict with and in breach of international law and Australia's obligations to the International Covenant on Civil and Political Rights, which were in part established to prevent such conditions as I was made to endure. My campaigns to bring awareness to my situation and the treatment I experienced has spanned more than 2 years now since being convicted in trial on 12 August 2011, and which campaigns include letters and statements to numerous organizations, media, and political parties, as well as staging a lone political plea for help from the roof of Acacia Prison on 28 March 2012, where I painted a broad message to then PM Julia Gillard concerning Australia's disregard for my basic rights. A brief of the event and the message to the PM can be found on page 21. The political plea on the roof was directly related to conditions arising from being denied legal representation and unfair handling of my case. While the injustices and misconduct I have experienced from the onset of this case through to arrest, trial, sentencing, and incarceration are too numerous to list for this inquiry, they are recorded in previous statements issued to the U.S. Consul, the Ambassador, and which are available to any person of the public or media upon request. With sincerity, I would say that mine is the most important case concerning access to justice and civil rights to cross the table of this inquiry. It not only demonstrates in harsh detail what occurs to an unrepresented accused person against a mindset of indifference to fact, truth, and fairness, but in particular how vulnerable to misconduct and injustice a foreign national is against such a system that denies legal representation to those who require it most. It also demonstrates the impact on one's life where procedural fairness and protocols are disregarded to ensure a conviction. Since incarceration following that brutal trial, I have met many other men, young and old, who have shared similar experiences to varying degrees. In the past 2 years, I have personally read the cases, statements, transcripts of approximately 20 prisoners while assisting them with their legal affairs after they too had been denied legal representation. The misconduct and methods used to ensure convictions, like in my case, epitomizes the dire faults entrenched into the very design of the Australian system of justice. These unscrupulous methods appear to be standard operating procedures condoned by, if not defended by, even our judges in the courts of law. But it cannot be overlooked that the system itself is comprised of individual people whose mindset creates and nurtures these faults. I invite the reviewer to read The Personal Side, page 44, expanding on my experience as a prisoner. Unlike civil and family disputes, matters involved in alleged serious offenses adversely affects the very life of an accused person, often resulting in a term of imprisonment wherein arises further, often irreparable psychological and sometimes physical damage through the adjustment to prison life, the exposure to hardened criminals and diseases, isolation from their children, and overall rejection by society, friends, and at times family. In a sense, a conviction can be equivalent to murder, for murder of one's life is exactly what occurs. In that same sense, it can be argued that an accused person who has been granted less than full equal access to justice and right to a fair trial before a court of law is being set up to be murdered and rendered non-existent. It can equally be argued that an unfair trial, which always leads to a conviction, is therefore nothing short of a form of human trafficking. With this in mind, it is my sincere hope that the Review Committee to the Access to Justice Inquiry take these issues and this inquiry seriously in order to implement remedies that satisfy both fairness to the accused in the name of justice and Australia's obligation to the International Covenant on Civil and Political Rights, which were codified to prevent such injustices. Life is not cheap, but precious. A price cannot be put on a life. Funding is no excuse to ignore the law or the life at stake. John Victor Ramses. In 2006, Dr. Carmen Lawrence had this to say about the growing crisis of accused persons being forced to face litigation in Australia without legal representation. Quote, "Most Australians would probably be shocked to learn just how often people face prosecution and conviction without any competent legal representation. Yet this is an increasingly common feature in our justice system, and it is clear that reductions with legal aid are a major cause of the increase. There is mounting evidence that more people are being forced to represent themselves in criminal cases, particularly in magistrates' courts. Research shows that it is almost impossible to obtain legal aid for summary trials, and there is no incentive for legal practitioners to take on such cases pro bono. In criminal trials, people have no choice but to appear. Those who are forced to represent themselves are at a great disadvantage, not least because they are unfamiliar with important aspects of the criminal justice system and may underestimate the consequences of failing to comply with directives from the court. Unrepresented defendants are unlikely to have adequate understanding of the law in relation to their case and may not be able to judge what evidence they should put in before the court. Furthermore, they may include irrelevant material in their submission and may lack the necessary objectivity to frame a proper defense. It is almost inevitable that they will lack requisite skill to ask the right questions and avoid those that are potentially damaging to their case. All of these shortcomings may irritate the court and will most certainly lengthen and increase the cost of the proceedings. Such defendants typically lack familiarity with the sentencing options available, to their obvious disadvantage. A person without legal counsel also runs the risk of a prejudicial response from the jury, who may assume that you can't fight a lawyer who believes in you. Legal aid was supposed to prevent such injustices. As a result of successive funding cuts and changes to criteria, there are now growing concerns that only the well-off or those in positions to liquidate all their assets can afford justice. That this appears to excite very little comment is in part due to the predictable accompaniment to the law and order chant with its implicit assumption that those charged are inevitably guilty. Dr. Carmen Lawrence, former Premier of Western Australia, extract from her book, Fear and Politics, 2006, page 70 to 72. Part 1. Brief of my case. On 2nd July 2010, shortly following a separation from my wife amidst a heated custody and access dispute over our young daughter, I was arrested on unsubstantiated accusations of sexual abuse against my stepdaughter. The accusation was reported by my estranged wife following the announcement that I intended to take the custody dispute to family court for resolve, where I would invoke the Hague Convention on International Parents' Rights. The accusations were traumatic enough, but it is the conduct and overall treatment of my case by the West Australian legal and judicial system that is solely to blame for all that followed. Most notably, being denied a lawyer as a foreign national, which underscored all other matters relating to fairness in my case, contributing to what can be proven to any person with an interest to know as a wrongful conviction of an innocent man and father. The lawyer is the first and often the only line of defense for an accused person. I was left to defend myself alone in a foreign country, utterly absent of any legal knowledge or support. Page 9. Personal data. Name, John Victor Ramses. Born February 15, 1960. Murray, Utah. United States of America. Emigrated to Australia 2nd December 1999 for the purpose of marriage. Married 11 November 1999 on Mullaloo Beach, Western Australia. Permanent resident status granted in 2000. From this marriage, a daughter was born, 26 June 2000. Background history of the case, a short list. Separated on 27 April. Began access and custody dispute over our daughter. Accusation was made by my estranged wife on 1 July 2010. Arrested on the accusation alone, 2nd July 2010. Jailed in Hakea Prison, West Australia. Bail was made on 25 August 2010, only with consular help. Began search for a lawyer. All lawyers required $30,000 to $50,000 up front to take my case. Being freshly divorced and alone in Australia, I did not have access to such funds. I held a job in manufacturing to support myself, which covered the cost of living. I approached legal aid in Midland, Western Australia. Legal aid was refused due to my having a full-time job. I approached the U.S. consulate for help in securing a lawyer, and asked for an observer on my case. The consulate responded by telling me that they could not get involved in the legal matters of a host nation. I was left abandoned to the whims of a foreign legal system without protection of my basic rights nor observers to ensure fair treatment. I had exhausted all leads from the list of WA lawyers the consulate had provided, as well as exhausting all options from the phone book, internet, and referrals. As one lawyer told me, I had fallen through the cracks of the legal system. This was unacceptable in my view, and it is these cracks that must be repaired. These are not cases to be simply won or lost, or treated frivolously, but are always a matter of a person's life at stake. Hearings and trial. Meanwhile, beginning from 18 November 2010, I faced hearings of which I did not understand and which were not explained to me. During pre-trial hearings, I explained to the magistrate my desire to have a lawyer and the difficulty I encountered in securing a lawyer. There was no concern for my predicament from the magistrate. The responsibility to secure legal representation was put back onto myself. As a foreigner, this was unacceptable. I had no choice but to face hearings and trial, but had exhausted all options of acquiring a lawyer. As a U.S. citizen, this was unheard of. No one should ever be forced to face litigation without at least legal advice, much less without a lawyer. As trial approached, being alone in Australia, the stress and fear of facing trial alone began to incite anxieties and angina attacks. I had suffered a heart attack in July of 1999, but which had not caused me any further complications until the pressure built up from not having legal representation. See Support Document 3. In the weeks preceding trial, the angina attacks increased. Stress caused insomnia due to constant worry and the fear of going to jail, combined with the heartache of missing my young daughter, whom I had not seen since 30 June 2010, the day before the accusations were made. In my mind, the battle I faced remained a battle for my daughter, as much as it became a battle for my life. With just 2 weeks until trial, I resolved that I had no choice but to attempt to defend myself. The only law firm to express interest in representing me was Talbot Oliver. However, they believed, in their view, that due to the trial being so close, they would not have time to properly prepare a defense, subpoena witnesses, and proof of fabrication of the accusations. They believed also that it was highly unlikely that the judge would extend the trial date. I left the office of Talbot and Oliver as I had arrived, despaired and feeling hopeless. In a pretrial hearing just days before the trial, I told the judge, who would also be the trial judge, that I had exhausted every option available to me to secure a lawyer and that I would have to represent myself. I imagined the trial to be a Judge Judy scenario. I couldn't have been more wrong. In my mind, it was still a battle for my daughter, a family court dispute, and not understanding the seriousness of criminal trials, nor the complexities involved. I felt that all I would have to do is prove with evidence the accusations against me had been fabricated, and for what motive. I believed that certainly a judge would see the evidence and desire to know the truth in the matter. However, in order to prove my case as being fabricated, I required 3 witnesses and a bank statement belonging to one of the witnesses, which proved that the alleged crime was fabricated. I informed the judge in front of the prosecutor of the witnesses and evidence I required for my defense, and explained why I required it. The judge informed me that I would have to subpoena the witnesses and the evidence, and told me that I could get the forms from the department near the lobby. In that department, the clerk's office, I was given only one subpoena form by the clerk and was told that I would just have to make copies of it myself if I wanted more. Explaining to the clerk what the forms were for, I was also told that only a lawyer can subpoena private bank documents without a court order. I had no lawyer. I was told by the clerk that the subpoena may not even be processed in time for the trial at any rate. The form was confusing, and I was at my wit's end. I felt defeated at every turn, in spite of trying to do everything right. To me it was a nightmare, unbelievable that such a situation could occur in Australia. The situation without a lawyer, forced to ask a arresting officer to assist me, and officer's willful betrayal of my trust. Not understanding the subpoena form or the subpoena process, with less than a week until trial, I at last resolved to contact the arresting officer to assist me in securing my witnesses and vital evidence. I explained to the officer why the evidence was important, that it would prove fabrication of the accusations, whereby clearing my name of all charges. That officer contacted the prosecutor with the information, who then paid a visit to my witness's residence that very day. As a result, 2 of the 3 key witnesses declined to get involved, and the vital document evidence I required for trial was conveniently ignored. The excuse the prosecutor would give me in trial concerning the absence of this evidence was that the witness did not know how to print it. This was unacceptable. It was vital evidence and not a trivial matter, as my life was on the line. Being without a lawyer, I could do nothing. I did not know what to do. The prosecutor had, in fact, inquired of the evidence and had likely viewed it for himself, as it posed a serious threat to his case. In that, it is my belief that the prosecutor dissuaded the witnesses from making it available in court, and I believe he dissuaded the other 2 witnesses from giving testimony supporting that evidence. The trial judge also knew this evidence existed, as I had told her so, and its importance to my defense. Nonetheless, even though my witnesses told the truth in trial, the prosecutor used the absence of the document evidence to discredit her testimony before the jury. It was a cheap shot, one I believed the prosecutor had intentionally planned to do so. See the full details of this matter in Support Document 1, page 50. Impossible conditions of trial without a lawyer. Concerning cross-examination, conditions causing risk of collusion. Refer to Support Document 1, Preparing for Cross-Examination, page 57 for details. Without a lawyer, I was made by the judge to pre-write all my questions I intended to ask the complainant during cross-examination. I was made to pre-write these questions in the week before the trial and deliver them to the judge before trial so that she could approve of the questions before being put to the complainant during trial during cross-examination. I only had the statement of the complainant to form questions from. I knew nothing about cross-examinations. I prepared a list of questions to the best of my ability without knowing what was going to be said by the complainant in the actual trial. 3 days before the trial, I delivered my list of questions to the judge as required. On Monday morning, August 8, 2011, the morning of the first day of trial, I was shocked that the judge intended to read aloud to the court all the questions I had prepared. This was done in an open court environment in the presence of the prosecutor and friends and family members of the complainant. The situation caused me considerable stress as the family members had access to the complainant and the state witnesses who were sitting just outside the courtroom in the foyer. At regular intervals, as my questions were read aloud by the judge, I witnessed certain family members of the complainant leaving the courtroom and then returning minutes later. This occurred multiple times. I feared that they were reporting to the state witnesses the questions I intended to ask, whereby allowing serious risk for collusion and opportunity to prepare fabricated answers before taking the stand. I asked the judge to please dismiss the friends and family members of the complainant and state witnesses if the judge intended to continue reading all my questions aloud in the court. I explained to the judge my reasons for this request. The judge told me this was a public trial and that they did not have to leave. Naturally, this caused anxieties and stress, and I became afraid of answering the judge concerning my intentions of the respective questions. In this atmosphere, I simply ended up omitting many of the questions I had prepared. The situation would not have occurred if I had been afforded legal representation on my behalf. Refer to Support Document 1, Preparing for Cross-Examination, page 57 for details. Conditions of actual cross-examination of the complainant. With the remaining questions I had been made to pre-write, and after the prosecution had examined the complainant, my list of questions, now edited and scratched out, were given to a court clerk to read to the complainant in my behalf. I was not permitted to personally speak to the complainant. Nothing in my pre-written questions addressed what the complainant had actually said in trial. My questions had been pre-written 1 week before trial. The court clerk read my questions to the complainant in a simple, linear fashion, one after another, allowing the complainant to answer. I was not given a fair opportunity to challenge the complainant's answers, most of which consisted of unsubstantiated slander. Neither could I ask for clarification on an answer or lead into other questions that an answer often required. I was helpless in every aspect. I could only sit and listen to the damning accusations and slander, as the jury also did. The court clerk was not qualified to do any more than read my questions, which were now edited and out of order and confusing. This only set me up to present as a bad person to the jury. Conditions of cross-examination of my former wife, a defining moment in the injustice. In this instance, I was permitted to personally cross-examine my former wife. It is important to note that many of the questions I had prepared for the complainant were similar in nature for my wife, but which questions, I believed, had been revealed to her and the complainant by her family members while the judge had been reading my questions aloud in court. It was during this cross-examination of my wife that I reiterated my concerns that the witness was tainted as a result of exposing those questions prematurely. Furthermore, my wife and I were still in the midst of a divorce after an otherwise good marriage of 11 years. Memories of that marriage, as well as the scar from its ending, were still fresh. I had not seen my wife since the previous June, before the allegations were made. Seeing her again now triggered all the emotions associated with those respective memories. In spite of the divorce and what she had done to myself and our daughter through this, I still loved her. Our love story was well known and recounted in magazines, the Sunday Times, and the Internet, and had been centered around our daughter and a series of strange events that had brought my wife and I together. See Take 5 magazine, 23 June 2006. This, combined with fatigue, stress, angina attacks, and bitterness for being separated from my daughter through such a cruel method, caused me to finally experience an emotional breakdown while attempting to interrogate my wife in trial. The slander she spoke from the stand was something dark and sinister, not the woman I had married and shared life with. Naturally, it cut deeply, further demoralizing what mental strength I had left. All of this weighed on me, in combination of my disdain for the justice system in Australia and its prejudiced treatment of myself, and forcing me to stand in their courtroom in that impossible situation. My breakdown caused certain prejudices in the jury, to my detriment, much to the prosecutor's delight. The judge, in my view, callous and indifferent to justice or my vulnerable, defenseless circumstance, simply told me to compose myself. How dare she, I remember thinking. Where is wisdom and honor and integrity in these courts? I was struggling alone in a ludicrous situation. The judge should have aborted the trial in the name of fairness and demanded that I be provided with legal representation, whereas it was obvious I could not defend myself to any measure, and whereas my very life was on the line. But indifferent to fairness, justice, or my emotional condition, the judge continued the trial to its conclusion and certain conviction. See transcript, support document 2, page 63. Being made to face trial in a foreign country with absolutely no knowledge or legal matters was despicable in itself. Being made, under those conditions, to also face and attempt to cross-examine my former wife and family members, whom I'd loved for 11 years, with memories and emotions still raw, was nothing short of barbaric. Post-conviction. Note: it must be kept in mind that while reading through these documents, that I was and still am a foreign national in Australia with absolutely no support in Australia, no recourse to ensure fair treatment. To say that I was frightened and desperate is an understatement. The reader should ponder what a situation must be like by imagining themselves visiting a foreign country, far from family and friends, and being accused of a crime against a local citizen and denied any legal representation or legal advice throughout proceedings, and to be told over and over that you're not in your home country anymore. Arrested for publishing to my U.S. website in a plea for help, desperate and frightened. After being convicted in an exceedingly unfair, biased trial, and now looking at some years in a foreign prison for crimes I did not commit, I pleaded with the judge to allow a continuance of my bail until sentencing in order to collect my personal belongings and prepare them for shipping back to the United States. The continuance was reluctantly granted. Upon arriving home, the events of the trial and the verdict guilty left me in a form of shock, a disbelief of what I had been made to endure by this justice system. I now had the task of having to call my parents and children in the U.S. and inform them that after all my ex-wife had won, I was going to prison in Australia. My parents, due to their age, were most affected by the news, causing despair and depression. I am the eldest child, my mother's only son. I had long planned to return to America in 2010 to assist my parents in their latter years. This had been an agreement between my wife and I. 10 years in Australia, Then, with my Australian family, I would return to the U.S. But the conviction took away my ability to do so. Years locked in a foreign prison, the loss of career options I had worked so long toward. There was so much lost. Life, to the people who put me in this position, is cheap. Everything from the previous year to that point had caught up to me, and I collapsed back at home, sobbing until finally, at long last, slept. It is impossible to imagine my mental state, except by those who have endured such situations of cruelty and injustice. They had taken my precious daughter and robbed me of my life. They mocked my country and my pleas to respect my basic rights, and forced me through a brutal criminal trial with no legal advice, representation, or support. They obstructed my evidence and witnesses to ensure conviction. Then, most certainly, they congratulated themselves on another case won. Just another day on the job. In the days following trial, between fits of sadness and anger, I began to collect and box my belongings. I couldn't get my mind around why I was boxing my belongings to send home, nor why I was going to prison. I was innocent. I could have proven the accusations to have been fabricated in a fair court of law. But fairness was not what they wanted. They wanted another conviction. Desperate to get the evidence known, my only recourse now was to post it all to my website, along with the details of the treatment of my case, in hopes that someone would see it and investigate and help me. My young daughter had been the foremost on my mind through the proceedings and trial, as the transcript confirms. I wanted my daughter back, and I would not allow her to live a lie, nor to forget about her father. I was determined firstly to that end, and in that I registered my daughter's name as a .com, and posted all the photos and videos of she and I through the years, and all my music I had written, and other things, so she would not forget the sound of my voice, nor the father she loved. I was a programmer, internet developer, and marketer. I had created numerous sites over the years with many Australian and U.S. clients. I collected all my personal websites onto one server in the U.S. and pointed anything with John Ramsey's to my daughter's website, so she would find it if she searched for her father's name on the internet. All of it was under an existing domain called AmericanDownUnder.com, which would become the site to which I would publish the evidence and injustices. Both I and my wife had been fairly well known due to our love story and popular radio station I created called Ghost Radio Australia. I was desperate for someone to see the site and the evidence and investigate my case. On the site, I invited the media in the U.S. and Australia to investigate. I had nothing to hide, but my former wife, the police and prosecutor, did. Unknown to me then, the prosecutor and police were watching my website. Some days later, the original arresting officer confronted me with an order to appear in court. The trial judge was also the judge for this matter. The judge revoked my bail and sent me back to jail, leaving my car in the parking lot and all my belongings still in the home, half-boxed. My despair and anger deepened. I managed to contact my former supervisor, who agreed to go to my residence and collect my belongings, including the important documents and evidence I had brought to trial. My supervisor and all my property have since disappeared, and all my efforts to locate either, including help from the consulate, have failed. Rumor is he was warned off from helping me by police, who may have confiscated my property as well. 2 weeks after being sent to jail for publishing to my website, the same arresting officer paid a visit to me in Hakea Prison, where he demanded that I shut down my website or risk having more charges put on me. I refused to shut down my website and told the officer that it would require a court order from a U.S. judge to shut it down, and that exposure of my website to said judge and to the media would expose the injustices I had endured, of which he was implicated in. I welcomed that exposure. He obviously didn't. No charges were laid, and my site remains in operation, where, maintained by my family in the States, I post birthday or Christmas letters to my daughter in hopes that she will find it. I had been arrested just 5 days after her 10th birthday. She is now 13. It's only a matter of time before my daughter learns the truth of what her mother and the Australian justice system did to her father to keep us apart. What then? For what purpose will any of this have served when she resents her mother and family in Australia? I have made certain that all my letters home, all the evidence, and all I went through in my battle for her is available to her, with copies in Australia, the U.S., and even in Finland. My family in America searches for my daughter, and will find her eventually. Sentencing and the token lawyer. My original sentence date was in September. I went to court for sentencing on that day. By this point, after all I had been subjected to without a lawyer, I told the judge that I refused to stand in court any more without a lawyer. I demanded to have a lawyer. The judge was not happy. I felt she was eager to pass sentence in spite of presiding over a barbaric, prejudiced trial that had convicted me, a trial the judge knew to be unfair and rigged against me. Disgusted, the judge apologized to the complainant and her family who had come to witness the end result of their handiwork and rescheduled the sentencing for 13 October 2011. On the late afternoon of the 12th of October 2011, a lawyer named David Fort contacted me by phone via the prison. Mr. Fort informed me that he had been assigned to my case for sentencing in the morning, but that he had not had a chance to read through my case due to receiving it only the day before. As this lawyer had not read my case, and only assigned to me the previous day, I had no faith in his ability to solicit on my behalf. He told me that he would talk further with me in the morning at court. On the morning of sentencing, 13 October 2011, Mr. Fort entered the courtroom and briefly introduced himself. We did not have the time to talk of the case, as the court was convened almost as soon as Mr. Fort arrived. Mr. Fort offered a vague argument, rhetoric for the show, but I knew the judge had already determined sentence and prepared her judgment long before. The grant of a lawyer, Mr. Fort, was only a token effort to satisfy my demand for a lawyer. I was sentenced to 6.5 years for crimes I did not commit. I would not be surprised if the judge had tacked on an additional 6 months just for inconveniencing the court by demanding a lawyer. In effect, I still had no lawyer, no fair treatment, no justice. After sentencing, bitter of the situation, I met briefly with Mr. Fort, who was now on the opposite side of a thick protective glass barrier. He had the nerve to ask me if I had any instructions for him. A bit late for that. But I told him, my only instruction is to begin an appeal, briefly explaining the unfair conditions in the trial and the injustices I had experienced. Mr. Fort feigned disdain for the situation and assured me that he would get an appeal started right away. I was taken back to a cell and then later escorted back to Hakea Prison, having but a flicker of hope that an appeal would reveal the facts and set me free and return my daughter. However, Mr. Fort never started the appeal and only brushed me off each time I contacted him on the matter. Note: being provided a lawyer upon demand for sentencing begs an answer to the question, why was I not granted a lawyer for proceedings and trial when it mattered? Obviously, there was certain power available to the judge to ensure a lawyer. Neither the U.S. consulate nor the trial judge made the least effort to ensure that I was provided a fair trial, which neglect came at a great loss to my life. Fairness to myself, as the accused, was wholly disregarded. Disregard of my appeal for 2 years to current, and political plea for help. The neglect of my appeal and further injustices following sentencing eventually led me to stage a lone plea for help on the roof of Acacia Prison, 28 March 2012, in hopes that a news helicopter would arrive from one of the local networks and film a broad message to then PM Julia Gillard that I had painted across the roof of J Block. The incident brought the United States consulate to the prison, and the U.S. ambassador in Canberra was notified. To date, for some yet-to-be-determined reason, and in spite of numerous grounds and merit and further consulate involvement, my appeal still has not been lodged with the Court of Appeals. Rather, my appeal has been willfully ignored by the current lawyer assigned to it. It has been more than 2 years now. Why? See also Appeal Issues on page 20, Obstacles in Prison. In closing Part 1, there should be no doubt in the reviewer's mind that the case constitutes a serious miscarriage of justice, nor that willful deceit and corruption played a strong role. There are damaging flaws in the system of justice in Australia, which are ignored and thus encouraged to flourish, rather than be remedied. This case should invite an investigation. There should be a Royal Commission inquiry into the legal and judicial system of, particularly, Western Australia, as my case is just the tip of the iceberg, as I have personally been involved in assisting many other prisoners who have experienced similar injustices, which funneled them into prison. I have documented a pattern, common methods used in each case to ensure a conviction. This system must be openly investigated, exposed, and corrected. I now live with these prisoners on a daily basis. Perhaps they are your son, father, brother, or mate. I know their stories and cases, and have documented each, and mailed those journals back to the States for reference for my book, Not on My Life. I see the despair in their eyes that once mirrored my own. I see the desperation. I also see the flicker of hope when they learn of me and ask, "Can you help me with my appeal or legal letter?" And I reply, "Yes, the best I can. I'm not a lawyer." This is a system that preys on ignorance to win convictions, and where there is no accountability at any level, free to reign to abuse basic human rights. It is, after all, a reflection of our society. It should always be kept in mind that you, or someone dear to you, could be next. There must be change. End. Part 1.